Good afternoon. My clients are right outside, they'll be right outside.
Okay, all right. All right, we're here in the case of Mary Braddock and Stephen Braddock, 2019 305, 648, and 649 respectively. And I believe we are here for plea or plea order?
Yes, Your Honor, we just have a little bit of an issue to address. We're going to amend the first charge to a second-degree felony. So that'll make count one a second-degree felony, count two a third-degree felony.
Okay, so there was a plea entered back in October,
Correct.
and the plea is charged.
Correct.
Now you want me to vacate the plea and amend?
Just as the count one.
Okay, all right, so what I would like is just go ahead and vacate the plea and take it again as
Okay.
count one.
That'd be fine.
So it's clear. So as to count one, I'll vacate the plea as to both defendants, correct?
Correct.
Okay, let's have both defendants sworn in.
Would you be solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
All right, and then I will address each of them individual. We'll start off with Mr. Braddock to the charge, the reduced charge of exploitation of the elderly person or disabled adult as a second-degree felony, which caps, I think, what is the level? It's below 50,000, but I don't know what it.
It's a level 7 offense.
Yeah, but what are the money levels?
10,000 to 50.
10 to 50, 50,000, okay, so it's a second degree felony. Maximum penalty would be 15 years in state prison and or a $10,000 fine. To that charge, how do you want to plead? And then Ms. Braddock, to, again, I'm going to vacate count one plea, and now to the reduced charge of principal to exploitation of an elderly between 10,000 and 50,000. The second degree felony maximum penalty would be 15 years in state prison and or a $10,000 fine. How do you want to plead?
No contest, Your Honor.
Okay, are you both entering the pleas freely and voluntarily?
Yes, Your Honor.
Did anybody threaten you, force you, or coerce you into entering the pleas?
No, Your Honor.
Okay, did anybody promise you anything in exchange for your plea?
No, Your Honor.
Are you now, either one of you, under the influence of any alcoholic beverages or controlled substances?
No, Your Honor.
Okay, by entering the plea, you give up the following rights. You give up the right to maintain and persist upon your pleas of not guilty, to require the state to prove you guilty beyond a reasonable doubt at a jury trial, the right to testify in your own defense, the right to remain silent if you don't want to testify, the right to confront and cross-examine the state's witnesses, bring in your own witnesses, and even force them to come to court if they're not cooperative, and the right to appeal. If you're not a U.S. citizen, you could be deported. Knowing all those things, you still want to maintain your pleas?
Yes, Your Honor.
Okay, and I think there's a factual basis for the plea.
Yes, sir.
I accepted it at the last time. So I accept the pleas finding that they're freely and voluntarily made. There's a factual basis for both of the pleas. So now we can move on to sentencing, I suppose. And the pre-sentence investigation was not over.
Correct.
Okay.
And Judge, there's my client's brother who's attending via Zoom. As long as he's not going to be testifying, then I won't invoke the rule before I make my presentation to the court.
Okay.
Judge, I exchanged emails with Mr. Andrew Braddock. I've not spoken to him, and I did not intend to call him as a witness.
Just as long as we have an understanding he's not testifying, then I'll allow him to listen.
Well, Mr. Braddock, Andrew Braddock.
Yes, sir.
Okay, is it your, is this person a victim or?
He's not a victim, he is a witness in the case. The mother is the victim who passed away.
Okay, Mr. Braddock, are you intending to testify at sentencing or no?
No, I am not. I am just making a recommendation of no incarceration.
Oh, okay. All right, so, and then I'll go ahead and mute you at this time. All right, thank you. All right, so does that clarify your issue?
It does, Your Honor.
Okay, thank you. You may proceed.
Judge, I'm going to take you the short way to where I would hope the court to go, and then if necessary, we can fill the court's information to you make a decision.
Actually, let me stop you there. Is there a score sheet?
Yes, Judge, I can send it to the clerk. I'm doing the amended one, so just give me a moment.
Is there one in the court file? I don't see one in the court.
I don't believe so. Let me, if I can email. They're going to be the same. I'll email the one I just finished over to clerk.
Do you know what they scored?
Yes, lowest permissible, there's no prior record.
There's no prior records, and the state's going to waive the guidelines, which is an open plea to the court. I'm going to be asking for a withhold and probation, and then I'm going to tell you the grounds for that.
Okay, all right. Then go ahead.
So, the proposal for the withhold is as follows. They both have no prior criminal record. This is a situation, in my opinion, of sloppy bookkeeping. Stephen had a dream to have his father and his mother on both sides of him while he and Mary took care of them. It's called a barn dominium. They actually purchased the property and developed it during the course of this time period. Money was transferred, money was taken. He paid some of Mom's bills. Mom may have paid some of his bills. He had power of attorney. Make a long story short, father passes away. Prior to the father passing away, he sits down with his son. He says, make that dream come true. Take care of your mom. Again, a lot of sloppy bookkeeping. But there was no criminal intent. This is family. They were family. Ultimately, the mother comes to the point where she has to be placed in a nursing home. The estranged brother, Andrew, not upset, very upset at the fact that his brother's not giving him information. Make a long story short, FDLE conducts an investigation, and here we are. He had to retire or resign early as a sergeant from Fort Orange Police Department. Decorated law enforcement officer. What I'm asking for is the court to sentence him withhold of adjudication, 5 years probation. It gets a little bit better for the court to do that. Number one is he would lose his pension if he's adjudicated guilty as a convicted felon. It would jeopardize his pension. Number two is the brothers, now that the mother has passed, no one has been appointed personal representative yet, but they've entered into agreement where Andrew will be the personal representative, and he waives his entitlement to the estate with the exception of they will allow him to own the barn dominium in New Smyrna. And a lot of logistics. We are today, though, going to order restitution in the amount of approximately $726,163.43. We'll stipulate to that. I'm not going to object. And then what I'll do is, when probation confirms all this, I'll hand them the agreement. I just have now a signed agreement. In fact, I have a copy for you. I gave a copy to the state. So civilly, all the parties have agreed. The reasons why I asked the court to not sentence them to any incarceration is I provided the court prior to the sentencing hearing, and I gave a copy to the state. He's got seizures. He's on medication. He's under the supervision of a doctor. And former law enforcement, we're going to have to put him in protective custody. He's not a danger to the community. He's not a flight risk. They have their home. He's got his job. I'll talk about that in a little bit. But there's no reason to incarcerate. With Mary, her daughter is right there. She's the primary caregiver for her granddaughter, so her daughter can work, and her son-in-law, who's a law enforcement officer, can go to work. Absolutely essential that she continue to raise her granddaughter. She, too, has no prior criminal record. A little bit of medical condition, but nothing major. Again, no prior criminal record. I don't believe there's a purpose in society for us to have to segregate them, especially with the COVID, especially with the medical
Can I ask you
issues.
something? If Andrew Braddock is not asking for incarceration, is the state asking for incarceration?
Yes, as an officer of the court, we've had conversations, and we've spoke about restitution is the most important thing, and if you incarcerate, so they're not seeking a prison sentence, but they're going to ask you for jail time. They have to, they're prosecutors. What can I tell you? I, as their advocate, are telling you why the court doesn't have to do that. And then we're going to leave it up to your good judgment and hopes. The other thing is, this property they have, they've got dogs, she's got a grandkid, they've got to maintain it, they've got to fund it, this and that. You incarcerate either of them or both of them, and that whole thing comes apart.
So what's the nexus as far as responsibility? Is there one that's more culpable than the other? I don't really know the facts of the case.
And I'll tell you,
I mean, I know she's charged as principal, and he's not. So I don't really know the connections between.
You know, we never really got into that degree of culpability, but hear me out. And I've done this, and I know we as officers of the court have to put ourselves in this, but mom's insurance bill comes up for the car. He doesn't have her checkbook handy, he cuts the check, or he pays cash, or whatever it takes. Then all of a sudden, one of his obligations come up, and it's clear. They use the mom's credit cards to pay it. But some of those things were funded with their own money. Like I said, it was a lot of sloppy bookkeeping. But the key for the court to recognize why there was no criminal intent was the fact that it was all the monies went towards this common goal of the barn dominium, with the concept of mom and dad on each side and them in the middle to care for them. And like I said, along the way, dad died. He said, carry on the dream for mom, take care of your mother. And then mom had to be institutionalized. She was in a nursing home, and then she ultimately passed away right after the plea. So I got to tell you, Judge, if they were driving around in fancy cars, wearing fancy jewelry, taking exotic vacations, and eating in the fanciest restaurants, yeah, I think I have less of an ability to articulate to the court that there was no criminal intent. But again, his father and he had a bond. You know, I feel for Andrew because he relocated to another state, has his own family, has his own life. But he was here, he was local. So as dad started to demise, he confided in son. As mom started to demise, they confided in son. And this was the common theme. You know, let's make this barndominium, let's make it a reality. So I can't tell you one is more culpable than the other. They're both sloppy bookkeepers. What can I tell you? But again, it's family. Sometimes we take out of the pocket to pay for mom, sometimes we pay out of mom's pocket to pay for us. But there's, you know, and this 726 is all established with really two pieces of real estate. A Mount Olympus condominium, townhome, that Mr. Andrew is going to have, and then the barndominium, which is, you know, has $400,000 or $500,000 worth of equity in it. Again, all with the proceeds of the sale of the mom and dad's home, and some of the money with regards to other accounts and this and that. Again, the state and I would have had a 2-week-long trial with battles of forensic accountants. I think in the end, there either would have been a judgment of acquittal or a directed verdict because of the fact there was no really any criminal intent. But the state and I communicated, and a lot of discovery was exchanged. And I think what we ultimately have is a good resolution to propose to the court. And again, the only difference of opinion I and the state attorney's office have is they would like to request of the court a period of incarceration in the branch jail. I'm saying that's not practical, nor is it necessary. You feel they need to be punished a little bit more than what I propose? House arrest. And when you get to that ultimate decision of sentencing, I have a few things that I further have to ask of the court with regards to probation. And I want you to get a flavor for what's going on so you can make a fully informed decision.
Yeah, it's tough to get a grasp because I really don't know the facts. Like for example, the restitution, you said $700,000.
$726,163.43. That agreement that I gave to
Yeah,
they are waiving it. They are waiving the entitlement to $726 in exchange for this resolution that they have agreed to. So the estate is resolved.
So in other words, even though I order it, they don't have to pay it?
No. You can order it because I want you to order it, and that's what I represented to the state as an officer of the court. What I'm going to do is provide that to probation, and it will show that it's satisfied. That's a civil agreement between the disputed parties, and it resolves the restitution figure. But you, as the judge of jurisdiction right now, you have to pay, and I have no problem.
Okay.
So again, everything came to a resolution towards the end with the mother's passing and the restitution figures, and now you're left with, you know, and what I say is 5 years probation, early term once he successfully completes the conditions. You know, it's not like they exploited his mother. Like I said, it ended up resulting in really bad bookkeeping. And another thing you have to understand, we had a lot of open discovery. I gave them documents of bills that were paid by my clients. I gave them financial statements. So there was no disguise here. There's no intent to try and hold back. And Judge, you know, that's really what I have at this point. I have other things I want to argue to the court. Let me give you an example of what they paid. They paid some of the real estate taxes on the parents' property. They paid condo fees. They paid for prescription medications. They paid for utility bills. They paid for the difference between what you get in Medicare for your nursing home and the extra in order to be in a private nursing home. They paid for the funeral. So all these things came out. Again, they were family. Technically, yeah, I think you could say a crime was committed, but there was no criminal intent. So again, I'm asking for withhold, probation. The state will make their presentation, and then when you ultimately pronounce sentence, whatever part, I'm hoping it'll just be straight probation and have a few things to ask them.
Okay. State, are you gonna have a presentation? Is anybody gonna testify?
No, sir, no. I've sent score sheets to the court.
Yeah, I see the score sheets.
What Mr. Place has outlined is essentially accurate in terms of what we're agreeing to, the mechanics of the resolution. There is a restitution figure that is undisputed between the parties. The number is $727,163.43. We will be asking for the court to order that restitution. I will submit an order, and I've spoken to Mr. Politis just a short while ago, a couple of days ago, about where that the payee would be based on the estate, and we'll figure that out. Now, when I get that information, I can submit an order with the figure on it and the correct payee. But the figure would be $727,163.43. The state does agree to waive the guidelines in this case, Judge. There are certainly enough here. There's more than enough evidence to support the charges. However, there is a lot of merit to some of the things that Mr. Politis put out, in my opinion, in terms of resolving the case. So that's why we're doing this. It's my position and our office's position that incarceration is appropriate. We are not seeking a prison sentence for some of the considerations mentioned by Mr. Politis. Most pointedly, the medical aspect of it and some of the history we have here. But incarceration is appropriate. This is a lot of money. And at some point in time, some of the things here, I'm not going to go through all the investigation, the forensic investigation on the finances, but certainly there's activity to sustain the state's charges here in terms of the use of the money. And so,
I'm still a little bit, you guys are way ahead of me on this one. There is a settlement agreement, I guess, in some sort of a civil case. Do you stipulate that this somehow will satisfy?
no. That is, and I understand we discussed that. There, between there being a civil matter, this having an estate issue and assets that are going to be argued about or could be argued about on the civil side, that's between the parties. The state, I'm not getting involved.
But we're talking about the same, we're talking about what's at issue here. I mean, the monies that allegedly are owed can be repaid with the properties which allegedly each may have an interest in.
I guess not dealing with probate or estate items and matters, because Mr. Andrew Braddock is here, he's technically not a victim in the case, but he would have an interest in the estate being the next of kin to the deceased. So in a collateral way, he has an interest in what those assets would be. That's I guess why they're talking between each other, their attorneys are. From the state standpoint, Stephen Braddock and Mary Braddock owe this figure to the estate of the mother who's passed. Where that money goes, where that order goes, and how they deal with that inside the civil arena of the probating and dealing with the assets between them.
I'm just trying to avoid the Department of Corrections becoming hypersensitive about this, and then
the reason I'm saying that way, Judge, is I don't want to get involved. I don't know what these assets really are. I don't know what they're worth, and I don't want to ask the court to direct.
Your Honor, with all due respect, if I may politely interrupt Mr. Sullivan, because I have a lot more command of the facts. This agreement does not alleviate the court's obligation nor the state's obligation in ordering restitution. Mr. Sullivan is absolutely right. He is not going to agree that this does satisfy. It does. It says so in black and white. But for the purposes now, today, you have jurisdiction, then we are going to order restitution, and then when it's satisfied, If I have to come before the court because DOC doesn't wish to interpret this correctly, I'll articulate my argument, and in fact, I'll go to probate Judge Hudson before that to make sure it's ratified by that court, so that way, and it very well may alleviate having to come back to you.
Okay, all right.
My suspicion is, yes, that will happen, but I don't want to go to take that step too.
I'm assuming you don't oppose to withhold leave.
And we're leaving that up to the court. We'll stand silent on that aspect of it. It does have the pension ramifications, as argued by Mr. Politis. We agreed to present this structured plea agreement to allow the court to have discretion.
Okay. All right. Anything else? You want to have any testimony or?
Both my clients have written out 2 pages of what I think to be very heartwarming to address the court. And I was listening to one of your prior cases and stuff. I think you understand that. Here's the problem, and it almost makes me cry. When you've got sibling rivalry, people take such crazy positions. This never would have been here but for them communicating. And that rivalry got him to resign and retire early, and got him to have to go through this criminal prosecution that has literally destroyed his health. And then it places the state in an awkward position because they can believe as much as I can tell them, but guess what? I'm their advocate. And so when I tell you, with the agreement, there's proof in the pudding that there really wasn't a theft. There was a misorganization and misappropriation of family money, including theirs. They put money out of their pocket to put the well inside, to upgrade the dirt road, to do this, to do that, the landscaping, the fencing. But that's not the issue. The issue is you're caught a little, not off guard, but with not as much information as I have. And I'm asking you, as an administrator of justice, a withhold of adjudication, straight probation is the right thing to do in this matter.
All right, thank you. And your clients want to say anything before I impose sentence?
You guys want to say? You do? Okay, they do.
Okay, if you don't mind coming up to the podium and they've already been sworn.
Yes. Good afternoon, Your Honor.
Okay.
I respectfully thank you for the opportunity to speak directly to you today. As you are aware, it's been a long 4 years. We have never been able to have our voices heard until now. As Sue's dementia progressively gotten worse, Steve and I were there every step of the way helping his father, Joe. We vetted and visited numerous top-rated local and care facilities, ensuring she would be well taken care of and close to us. Joe asked us to help him, and we were more than happy to help him. There was no other family involved in any of these early decisions, and really any decisions thereafter. Sue was placed in Grace Manor Assisted Living, a few miles from where we lived. It was a beautiful place, and during her visits, we became quite close to the staff, residents, and they knew us both by name. After looking for a wedding venue with no luck, we asked the staff if it would be okay. They were overjoyed to have us there, so we decided that this was going to be the place where Steve and I got married, so his mother could attend as well. We also had Joe medically transported there so he could attend there and be with his wife as well, to watch us on our special day. Like many families must do to take care of their sick elderly parents, I agreed that I would quit my long-time standing job in dermatology field to help take care of them. And even though I had worked extremely hard to gain the position I was in, I was honored to take care of them as they were like my own parents. We've had many conversations with Joe about the final wishes and what he wanted. Once again, no other family member was around and offered any help. During that time, Joe helped devise the plans to purchase the barn that we would eventually live in with us. He would live in with us. He would ask us frequently the status of the build and let us know how excited he was to start his new chapter with us. Unfortunately, very painful for us, he fell sick from a fall, suffered a brain bleed, and never recovered. Steve and I planned a celebration ceremony for Joe after the service. We did this all on our own. No other family members helped, and in the planning or in any financials. Steve and I have never been on the side of the law. We have never been in any kind of trouble, not once, not ever. We made mistakes through grieving the loss of our father and caring for Sue. We did not consult an attorney simply because we thought we were doing the right thing. With all of our hearts, we honestly believed we were honoring his father's wishes and did take care of Sue while we oversaw her care, visiting her frequently. Again, we are the only family members in Florida and the only ones actively participating. We are blessed with a 1-year-old granddaughter, Olivia, Megan's daughter. I watch her weekly, and I've grown very close to her. I see Olivia several times a week, other than that too as well, and I've also recently reinstated my cosmetology license to go back to work in my first profession. Steve has had to pick up the pieces of a shattered life and a career and reinvent himself. Using his experience in law enforcement, he still feels the need to serve. So he started working for firearm sales and education. He and his partner are lead instructional classes out on our property to promote firearm safety and teach others. We ask you, Your Honor, to look at the deal we have signed on today to make this right. We are asking for you to consider all of the circumstances and all of our good deeds, not just the ones written in our plea form. We are asking no jail time and no probation so that we can go back to work and continue to help our daughters and their young families and their growing young families, and Steve to maybe continue to work, earn an income, and use his knowledge and experience in positive and a productive way to help other people. We humbly thank you, Your Honor, for letting our voices be heard today. Thank you.
All right.
Your Honor, I wish to thank you for the opportunity to discuss the situation with you this afternoon. This has been the most significant set of events that I've ever experienced in my 52 years of life. In 1994, I entered into the law enforcement profession, not knowing what to expect and did not have any expectations. During the course of more than 23 years, I suffered numerous injuries and saved many lives. As a result of my everyday policing activities and in doing so, I received a variety of different commendations and medals, such as the Medal of Valor, Police Officer of the Year, Purple Heart, Awards of Merit and Achievement. I love my job and respected every aspect of the profession, and every day I put the gun and badge on, I always went to work with the mindset of doing the right thing. Throughout my long career, my father was always there for me, during the good times and the bad. He always guided me and gave me valuable advice regarding all aspects of my life and career. My mother and father were not just my parents, they were my best friends. My father agonized over the fact of my mother's rapid decline with her dementia, and shortly after she fell and broke her hip, it was determined that she needed constant professional care. And we went to several different facilities to find the best one suited for my mom's long-term health care. Grace Manor was at the top of the list, and later we made her very comfortable there, and she loved it. Grace Manor, being so close to the Port Orange Police Department, I routinely visited her there, on duty. Many of the visits I did not sign in due to being in uniform, and while off duty, I was known there and routinely did not have to sign in there either when I was not in uniform. During my time in Grace Manor, I made many friends, and I feel my presence was positive and helpful with many of the residents. One early morning, my father called me shortly after falling and hitting his head. We immediately responded to his side. Unbeknownst to us, his injuries were more severe than first thought. Shortly thereafter, we called the EMS, and he was taken immediately to the hospital, where it was discovered that he had a brain bleed from head trauma. My father was my rock. Watching him as he slowly declined was extraordinarily painful. In hopes my father would fight the fight and recover, we decided to get married and thought how great it would be to have our wedding at Grace Manor and have both my mom and dad together. So we arranged to have my father transported to the assisted living facility, and we were later married with our immediate family and residents, and it was truly meaningful event. The next several months, we staggered after our marriage. My father's passing was the most shocking to us, and we did not realize how many moving parts needed to be handled and figured out. We were of the opinion that we could handle things on our own following my father's wishes, and unfortunately, we did not seek professional assistance to help guide us through the many complicated processes. Please note, my mom's care was always our top priority. As time progressed, my long-standing, deep-seated issues with my brother materialized, and once again we were at odds. After receiving notification that the allegations were lodged against me for things that were not intentionally committed, I was faced with an early retirement from the police department, and I made the decision to end my career and retire 14 months before my 25th year of service. As time progressed, I quickly realized that now I was being accused of wrongdoing, and I was on the other side of the law for the first time in my life. This action broke me. I went into a severe depression and sought out mental and health treatments and medication. I have never intentionally broken the law, and never in my life would I have thought that I would be accused of doing so. I have deeply regretted all the circumstances which have led us here today, and I pray that you will consider many of these circumstances in this case, all of which were not intentional in any form or fashion, and please release us from this nightmare and grant us no jail time or probation so that we can continue with our lives and so that we can be a part of our loving and growing family. Thank you, Your Honor. I really appreciate you letting me speak about this.
Thank you. Anything else?
No, Your Honor.
All right. Any additional argument?
No.
All right, thank you. All right, I hate to say this, but with respect to, I understand, I think, I have somewhat of an understanding of what's going on between Mr. Stephen Braddock and his brother. I'm still at somewhat of a loss as far as Mary Braddock. I just don't have a good grasp for what it is that she actually did to land, other than maybe being part of the transactions at some point in time. Other than that, I don't really know. Being a married man myself, I'm sure my wife and I do a lot of things together, but I never would think of her as being a principal to anything that I would do if it was just sort of run-of-the-mill type transactions that we husbands and wife commonly do. Nonetheless, I think she's entered no contest plea, so I'll go ahead and proceed with sentencing. I do want to say something before I impose sentence. These kind of issues are very, very prevalent in our community, and this particular situation is not uncommon at all. There are people who have multiple children, and some of those children wind up taking care of the parents in the end, and some others from far away, for a variety of reasons, can't take care of them. So a lot of times I think there's a belief that a fiduciary relationship exists, whereby those who are caretakers are stewards of both the financial means of the parents as well as the caretakers. Now, these unspoken scenarios don't compensate those who are the caretakers, because those who are caretakers wind up being the ones who fund a lot of the caretaking, both in terms of time, which is never compensated, and in terms of financial means. That doesn't totally excuse the responsibility to be a good steward and be fair to those who are not here, but at the same time, I think is often unappreciated by those who are not here, as far as the effort that is required to be put in place in order to, to care for loved ones up until the end of their lives. Nonetheless, I don't know if this is it seems to me that the civil litigation has driven somewhat what's happening here. Whether or not this is being used as leverage for civil litigation or whether or not this is a legitimate crime, I don't really know. All I can do is just take what's in front of me. I'm really confused about the state's position asking for jail time, but not asking for an adjudication. So I don't really know what the source of the desire for jail time or what it will accomplish here. So be that as it may, what I'm going to do is, as to both defendants, the sentence will be identical. I will withhold adjudication, place each of them on 5 years probation, impose court costs and cost of prosecution as a condition of probation, will require restitution to be paid to the tune of $727,000. $727,163.43. I guess I'll leave it up to Mr. Politis to explain that to the Department of Corrections, how that is going to be accomplished. I suppose I'll give them, I don't know, is 3 years enough to pay all this money?
There will be more than enough time. I'll endeavor to meet with a director of the Department of Corrections and establish the settlement agreement and make my arguments.
Okay, so I'll give 36 months to make full satisfaction on the restitution. Mr. Braddock, Andrew Braddock, indicated before I muted him that he wasn't seeking incarceration, so I don't really understand the need to incarcerate anybody if nobody's asking for it, other than the state's general desire for it. Each of you will have 30 days to appeal the judgment of the court.
Judge, no disrespect to interrupt you. I addressed the court previously. I told you I had a few things to say to you with regards to probation.
Yeah.
I address those now. One is, being a former law enforcement officer, it's okay if they both report on a phone-in or mail-in basis, so he doesn't sit in the office and, heaven forbid, runs into somebody he arrested.
For the first year, I think I wanted to check in. After that, I don't have a problem with switching to that. Once we establish a good pattern.
Okay, so 1 year you want them to check in.
That is correct, at least for the first year.
Number two, he works in a firearms industry. We will still allow him to be able to sell and instruct people on firearms.
Does he possess a firearm?
I'll make sure he doesn't. He won't possess a personal firearm if the court makes that a condition, that's fine.
Well, that is a requirement. You cannot possess a firearm.
But he can work in the firearms industry.
But he may work in whatever field he's entitled to make a living, so.
Okay. The restitution would be made payable to the probate account, and there's 2 probate lawyers on each side. I'll get with them to get a proposed order, and we'll get something.
I'm assuming that Andrew Braddock is going to become the PR
Correct.
of the estate, so technically he has a say in whether or not this is going to be, the restitution has been satisfied or not.
He already said so in the document.
All right, so I would just ask Mr. Braddock to contact the Department of Corrections maybe next week.
Yes.
Identify yourself as the
I'll actually speak to his lawyer, not to interrupt you. He has an attorney here in town.
oh, okay. Well,
So I'll take it to her.
I'm not so sure the Department of Corrections is going to want to talk to the lawyer. I think they're going to want to talk to him.
Maybe. And lastly, would the court be inclined to waive costs of supervision?
I'll cut him a break. I'll waive the cost of supervision as to Mary. Okay?
Thank you, Your Honor.
Between the 2 of them, they'll still have to pay the cost of supervision as to one, okay?
Thank you, Judge.
All right.
That's all my business before the court. May I be excused.
All standard conditions of probation are applicable. The only special condition of probation is the restitution unless the state is seeking any additional condition. Okay, and then you have 30 days to appeal the judgment of the court. Probably too late to check in with DOC today. You'll be given a sheet. You need to check in tomorrow.
for both.
Thank you all very much.
Thank you, Judge.
Thank you, Judge.
Do you want the settlement agreement to be filed in the court?
Yes, Your Honor. Yes.
Okay, so I'll be
I
filed.
provided a copy of the statement.
All right, thank you very much.
Thank you, Judge.
Thank you.
Apparently, before the holidays, they used referrals, didn't get their fees enough, so we have to have
were set aside for what?
Well, we have to, I'm asking you to write room as a set aside because they weren't given enough time. They weren't done